and I'm not sure why.
Okay. Well, I'm going to introduce you again. This is my Curt Levey, and Curt, tell us more about the Committee for Justice.
Sure. Well, we were founded in 2002 to fight the obstruction of President Bush's judicial nominees, and our role grew over time to be a larger focus on the courts and constitutional law, and all in the mission of limited government. And then, more recently, we've been doing a lot of tech policy because that's where the fight is right now over limited government. As you probably know, within the conservative community, they're kind of split between those who want to throw out a lot of the typical anti-regulatory philosophy because they're so angry at big tech for good reason. But anyway, that's sort of where the focus, at least on the right, is right now, about limited government versus bigger government, free speech versus less free speech.
And so you guys are more than just a judicial watchdog in terms of keeping track of what the court has done and reports. You also are an advocate for a more constitutional. Is that fair to say?
Yeah, I mean, ultimately, we exist because we believe in constitutionally limited government. Basically the type that our founding fathers dreamed of. One that's consistent, frankly, with individual liberty.
Awesome. So then, that's a perfect lead into talking about constitutionally limited government. Most people can have heard the conversation about the massive conservative majority that's in place now. And so there were some talks about the Democrats coming in and potentially changing the court, packing the court. And we lost Curt there for a second. So I'm going to keep talking about this issue. People may not know there actually is a history where Franklin Roosevelt talked about packing the court beforehand. Roosevelt wanted to enact all of these progressive legislative changes, things that certainly seemed larger than the power that the president had. And the Supreme Court balked at that idea and said, we're going to find most of this stuff constitutional. And the president responded, well, I'm going to do stuff by executive order, and you guys are going to have to stop me. And we're in the middle of a depression, and then they were in the middle of a war. That great extension of executive office power is something that obviously, when the system of checks and balances, we expect the Congress to have some check on it, but we also expect the Supreme Court to have the ability to issue a further check upon that. In the end, Roosevelt chose not to enlarge the court beyond the 9 members that it had been in. So Roosevelt's decision to not enlarge the court maintained that status quo of 9 members. But now, Curt, when we talk about the idea that the Republicans may have played a little fast and loose with the games to get the court where it is now, do you think it's fair to go back and talk about Merrick Garland and then go forward from there?
Sure. Again, I'm having a bit of trouble hearing you, but I suspect you were asking about the push on the left to pack the court or otherwise reform the court. And it did start with Merrick Garland. And, they somehow figure that they're owed, the left, that is, that they're owed 2 justices. They feel like Merrick Garland should have been confirmed. They also feel like Barrett should not have been confirmed. Of course, that doesn't really make any sense. I mean, if you think that a justice should not be confirmed in the final year of a presidential term, then Garland should not have been confirmed, and Barrett should not have been confirmed either. But somehow they think that they're owed 2, and so they want to add basically 2 more liberal justices to the court. Some want to add 4.
I think Curt is having some connection problems there. I'll take up that part of the conversation. The thing about it was, of course, that Scalia died, and nobody expected Scalia to die that suddenly. And so when Scalia died, Obama was in power, and he had the option of, and he did actually appoint Merrick Garland, but the president of the Senate, our friend
Merrick Garland was not confirmed and did not get a hearing. Now, I know a lot of people complain that he should have, but look, Republicans, McConnell in particular, had already declared that we are not going to confirm a nominee in this final year of Obama's presidency, and to have gone through hearings that would have been, in a sense, fake hearings, because they had no intention of confirming him, in which they would have had to do what Democrats do to Supreme Court nominees and, beat him up to try to justify not confirming him. I think it was just better to be honest and say, look, we're not confirming him, and there's no point in having a hearing.
And this is sort of the real political power talk of what happened, because the situation was reversed. I mean, the Republicans made all sorts of, we're not going to do this because, it's in the last year and we think the people ought to decide, and elections have consequences. And so they said, because it's the last year of the president's term, we're not going to make a decision. But then, of course, when Ruth Bader Ginsburg dies, it is in the last year of Trump's thing. And so the Democrats said, well, you made all these statements. And to be fair, Republicans and Democrats have both completely flip-flopped on the issue in terms of what should happen at the end of the term, where their positions are. In fact, we can go all the way back to Joe Biden making statements, I believe, 20 odd years ago, where he has flip-flopped from his position back then. So this is just real power.
It is, but and some of the Republicans have spoken out of both sides of their mouth. But McConnell has been consistent. McConnell has basically stated the rule as where the president's party does not control the Senate, the opposing party will not confirm a Supreme Court nominee in the final year of that president's term. So McConnell has been consistent. And actually, if you look at history, not surprisingly, that's been the rule, because it's all about power. Typically, when there's been a vacancy at the end of a president's term and the Senate is controlled by the same party as the president, the nominee gets confirmed. And when it's not controlled by the same party, the nominee normally doesn't get confirmed.
And so then is the typical
pretty
reaction,
much simple as that.
And then is the typical reaction that the party that gains power says, well, we're going to change the number of members of justice? Or is that unique to this situation?
Well, the last time we saw such a big push to change the number of justices was, of course, under FDR, and it was similarly ideologically motivated. FDR was on 1937 that the justices were striking down some of the New Deal era legislation as unconstitutional, and so he wanted to change the court. And his plan was that when justices reached a certain age, that you would add another justice to the court. And even though the Democrats had enormous majorities in Congress,
the Democrats then did refuse to expand the court, which is an interesting thing, because you think about back then, a lot of Democrats made decisions based on what they thought was the good of the system, as opposed to the good of the party. I definitely was worried that we're so partisan now that you couldn't trust anybody to make a decision for the good of the system as opposed to the good of the party. But how close did the Democrats come to trying to pack the court this cycle?
Well, fortunately, they only have a tie in the Senate, with Harris being the deciding vote. And I don't think that's going to be enough. People remember that even during FDR, with enormous Democratic majorities, they would not go for FDR's court packing.
Right. And the other interesting thing about it is that, there is a with the 50-person balance, and then Kamala Harris, the vice president, being the vote that gives them a majority, there still is a question in terms of, what would the outcry be? Because that's something that I think most Americans fundamentally, and I haven't seen any polling numbers on this. I don't know if there are any, but is there a popular opinion about the idea of court packing? I mean, has there been polls?
Yeah, if you look at the polls, most people are against it. And, I think that's pleasantly surprising, because you wouldn't think most people follow the Supreme Court, well
Right.
enough to know whether court backing is good or bad, and probably don't know that the number has been set at 9 since about 1869. It's not set by the Constitution, but it's certainly been set by precedent now for, over 100 years. And, people, I guess, know more than we sometimes give them credit for, because the vast majority of people oppose, playing with the number of justices on the court.
Right. I think it's also important that when we do polling, we say Supreme Court and not the Supremes, because otherwise you'll get Diana Ross for every answer. I'm sure you hear that joke way too many times. So that's interesting. We talked about court packing. It's probably not going to happen. So now we have a breakdown that a lot of people were worried was going to be 6-3 decisions across the board. But this court actually came back with a surprising number of unanimous decisions. And a lot of people said the court's trying to make a statement with that. Do you have any thoughts about that?
Well, I do. Even though Roberts may no longer be the swing justice, it's probably Kavanaugh. Roberts is still the chief justice and has a lot of say in. Roberts has always been a consensus man, does not want the court to be viewed as conservative. And so I think he did try extra hard this term to, if not have it unanimous, have it be 8-1 or have it be, otherwise non-predictable. It was really only on the last day of the court, when we had the decisions in the Arizona voting rights cases and the California donor disclosure case, that and excuse me for
no problem.
cough, but those were sort of the expected 6-3 configurations. But other than that, you really have to say it was a very moderate, consensus-based term with many unexpected configurations.
Gotcha. Well, so you mentioned the first case. I'll say Americans for Prosperity versus Bonta, which was the non-for-profit disclosing its donor list. And for people who aren't aware, if you give money to 501c4, like say People for Liberty, or I would imagine Committee for Justice is also a 501c4. So if you wanted to donate to either of our organizations, Curt and I can both guarantee that we will not release your name to the general public. And the argument was, and you can correct me if I'm wrong, is that essentially it's both a Fourth Amendment but also a First Amendment argument, that the court said it would have a chilling effect on speech if all of my potentially on my speech, if all of my political donations were published. I couldn't donate to a cause that I supported because I might have to face consequences for that. Is that a fair summary?
Yeah, the court didn't even need to reach a Fourth Amendment issue. It basically decided it under a case from the 50s involving the NAACP, where Alabama tried to force them to disclose their membership list, not for any legitimate purpose, but as you can imagine, Alabama did not like the NAACP back in the late 50s, and was hoping they would just leave the state, and went all the way to the Supreme Court, and the Supreme Court said that if you have to disclose this, it has a chilling effect. People worry about being harassed, or probably in the late 50s even worse, and that therefore it violated the associational rights, the First Amendment free association rights of both the organization and its members, and therefore Alabama could not compel that disclosure. And this case was largely based on that case.
And it was go ahead. I was just going to say it was the California Attorney General who actually was the person being sued, because California had implemented this as a law and was requiring Americans for Prosperity to release their list. But obviously this, now the Supreme Court has ruled on it, it is the law of the land.
Right. I don't know if you were saying who was being sued. It was technically the Attorney General of California. And that went from being, now it's Bonta. But in any case, it just happens to be the Attorney General's office who enforces the rules regarding nonprofit filings. So
Gotcha.
that's that. Yeah.
So that definitely is one of the big cases. The last week did, as you mentioned, see a flurry of cases that were not unanimous, that were more decided along party lines. Are there any other ones that sort of leap out at you that you would say, oh yeah, this was a big deal, this was something we weren't expecting?
Well, the other one from that final day were the Arizona voting rights cases. Basically, there were two provisions in the Arizona law that were being challenged. One was the ban on ballot harvesting, and the other was the requirement that you vote in the right precinct. I'm sure the Democrats would say that that's a return to Jim Crow, but I think all of your viewers know that that's those are common requirements. But that's sort of the way these days the Democrats look at ordinary requirements, like the ones reinstituted in Georgia recently, as being Jim Crow. And the court said, Alito for the majority, that you can't just look at whether anything, one little provision has a disparate impact, because you can make that case for anything. You can say, well, a different percentage of each race tends to vote in the wrong precinct, therefore this is racist. He said you really, you would have to show a big disparate impact, and you have to look at the totality of the ways of voting. So, yeah, maybe a political operative can't come and pick up your ballot, but you can mail your ballot in. So you can't just isolate one feature and show that there's a slight racial disparity. And, I think given sort of the new democratic philosophy that any check on voter eligibility is racist, I think this, was an important pushback from the court.
Well, and it's interesting that people understand that the only thing about it that the Democrats at least were originally challenging in this one specific thing was saying, if you happen to vote in the wrong district, and it wasn't even like an adjacent district or anything, it was anywhere within the state. I grew up in Texas. That's a big state. The idea that my ballot should count from, even though I live in Galveston, if I were voting in if I put it in El Paso, that seems almost mind-boggling that somebody would say, oh no, that any ballot should count. And the argument that I believe they made is they said, well, it was only for national candidates. They're saying only for president because the president is a statewide candidate. But I think almost everybody would agree with the basic consensus that the court came up to, that, yeah, it is not an unreasonable burden to say you have to vote in the place where they're going to be able to accurately say, oh yeah, you are a registered voter in this district. And
no, that's been, I know my entire life, that's been a requirement. It's a common sense requirement. You want people to vote in the right precinct, because very often for local elections, the candidates and races differ from precinct to precinct. So, there's a very valid reason why you want to motivate people to vote in the right precinct. So it's silly. And until the recent era where everything is racist according to the left, I don't think anybody really questioned it.
Well, so then that leads me to an interesting thing. One of the fascinating things about the court is that as important as the cases that they decide are the cases that they let slide or let the existing ruling stand. And so one of the cases that they didn't hear, before moving to DC, I was in Massachusetts for 25 years. And people who don't know, New Hampshire used to be a solid red state, but Massachusetts was exporting Democrats north of the border faster than New Hampshireites could raise them. And so Now, during COVID, we had this scenario where New Hampshire, which doesn't have a state income tax, had a lot of people who worked in Massachusetts, and they had to pay state income tax in Massachusetts. And when COVID happened and everybody started working from home, these workers, employers, the state of New Hampshire said, hey, these people shouldn't have to pay income tax in Massachusetts anymore. However, that went through the court system, and the Supreme Court said they were going to let the ruling stand. So can you tell us a little bit about that case?
It's always hard to know why they let something stand. I mean, of course, the practical result is, that they will have to pay the taxes, but, one can only speculate. Sometimes it has to do with, not trusting there could be either there's not 4 justices that want to hear it, or, that's how many it takes to grant a case. Or sometimes there are 4 who would like to hear it, but don't trust that they'll have a 5th vote for the outcome that they'd like. So you just never know. Sometimes there's procedural reasons. It's not a good case for procedural reasons rather than substantive reasons. And I won't, I can't speculate on why they do, unless one or more of the justices dissents from the denial of cert, and goes into sort of the debate that was, hints at least at the debate going on in the court. You just don't know.
Right. It was interesting. I know Thomas and Alito said that they would have heard it, but I had never thought about the fact that sometimes people choose not to hear a case because they're worried about the fact that if they establish a decision and they don't get the decision they want, stare decisis will prevent them from being able to return to that case. I'd never thought about the fact that that's actually one of the political strategies that happens. Well, we have a question from the gallery. For you, what was the biggest surprise out of the Supreme Court this session? Is there anything that shocked you?
That's a good question. Well, I certainly wasn't surprised by the Obamacare decision. Of course, we were told during the Barrett hearings that if she was confirmed to the court, Obamacare would be struck down. And if you remember, every Democratic senator had a few examples of constituents who would die because of that.
Right.
Well, good news is those constituents will not die, because Obamacare was not struck down, and there never really was any chance that it was going to be struck down. I mean, you can certainly make a legal argument, but it's I don't even want to get into the details, but it had to do with the fact that it was originally upheld as a tax. And once they zeroed out the tax, you can make a strong argument that it's no longer falls under the taxing power. But in the real world, that's too technical an argument for the justices to do something that would have, be extremely controversial. So, I think we all knew it wasn't going to happen with or without Barrett on the court. So that was not surprising. Some of the ones.
I was going to say, you mentioned Justice Barrett. Do you think that she surprised a lot of her detractors in the way that she voted this cycle?
Well, I mean, again, she was more moderate than they warned us. I mean, it's always hard to know if they actually believe their own rhetoric. Going back to O'Connor, every new Republican justice was going to take away women's right to an abortion, and that, hasn't turned out to be true, obviously. So they always exaggerate. But, she was quite moderate. I mean, people are talking about it now as a court with, 3 solid liberals, Sotomayor, Kagan, and Breyer, and, 3 solid conservatives, Thomas, Alito, and Gorsuch. May be a solid libertarian more than a solid conservative, but a solid limited government guy. And then basically 3 votes in the middle that are up for grabs: Barrett, Kavanaugh, and Roberts.
And so,
and I think that's accurate. So again, to the extent they actually thought she was going to be a right-wing ideologue, then yes, I think they're pleasantly surprised. Even on things that she cared, to the best of our knowledge, strongly about, like religious liberty, when it came to the cases involving COVID restrictions on churches, she took a sort of moderate down the middle line.
Well, and so that's a great example, right? Catholic Diocese of Brooklyn against Cuomo. Now that is, it's exactly what you said. It's a COVID case. The Andrew Cuomo issued an executive order essentially limiting the First Amendment, right? Both religion, establishment of religion, and right to assemble. And not shockingly, that court case made it all the way to the Supreme Court. Although, am I misremembering? It did at one point in time, New York tried to reverse itself so that the case wouldn't go to the Supreme Court.
I don't even remember, but they were not successful. I mean, it was on the shadow docket. It wasn't, argued in oral argument, but it was a decision by the court. So they were not successful in stopping a ruling.
And so then, the Supreme Court was pretty straightforward about it, right? I mean, they said this is basic First Amendment.
Yeah, I mean, in that handful of cases about restricting churches from having live gatherings, it was pretty much a clear, either the interests of the state outweigh the freedom of assembly and religious liberty, or they don't. And those are the lines along which the justices split.
Now, the one thing that I found that was really interesting about that is that Roberts writes in dissent that he doesn't think that there's a need for injunctive relief because New York has already rolled back the restrictions. That seems like an odd position for him to take.
Well, I mean, look, they very often, whether we're talking about standing or mootness, they very often find an excuse not to decide a case that they don't want to decide. I mean, for example, in the Obamacare case, they used standing to not really reach the heart of the issue. And so it might have been that Roberts wanted to do that. I mean, again, mootness is, plenty of malleability. There's the capable of repetition but evading review exception, right, where, for example, in an abortion case, it's never going to reach the Supreme Court within 9 months. So, if it was a woman was the plaintiff, something like that, where they'll, right, where they can and do make an exception. So, I hate to be a cynic, but I often look at mootness and standing as just another way to reach the result you want to reach.
Yeah. And for me, it felt like something that Robert said, you know what? I can vote with the liberals on this, not affect the outcome. And they'll say, oh, yeah, look, the court isn't as biased as we think. Now, one of the other really fascinating cases for me was, like you, I actually started off as a software guy, and there was an interesting information system case where a police officer who had permission to access a computer system but didn't have permission to access certain records was essentially the challenge was that was a violation of somebody's rights because this person shouldn't have been looking at those records. And that seems like a very specific case, but an important one for the court.
I think so, Van Buren. Even though that's a relatively old statute, the Computer Fraud and Abuse Act, it really hadn't been tested in the Supreme Court. And this case was about what unauthorized access means. Here you had a police officer who accessed information for an illegitimate reason. He basically was being bribed to do it, but he did, right, have access to the computer. And, there's language in that statute, which if you read unauthorized too broadly, it would mean that, if there's a policy at work that you're not supposed to use your computer for personal use and you check the sports scores, that you've, violated a federal statute. And, right, as a government, as a group that favors individual liberty and limited government, we sometimes differ with traditional conservatives on law enforcement issues like this. We do not think that federal statutes, or really any statute, should be read so broadly. It's related to the rule of lenity, but especially in the criminal law area, the defendant deserves to have it read narrowly. And in this case, it was the common sense reading, because clearly Congress did not intend that anyone who checks sports scores at work is guilty of a felony. So we submitted an amicus brief in this one on the side of the police officer, and the Supreme Court came down that way.
That's a fascinating thing, and you talk about the fact common sense. I do occasionally worry that common sense is going away, but this was certainly a relief to see what was the obvious decision in this case. I want to talk about one of the unanimous decisions that I was pretty interested in, FCC versus the Prometheus radio project. And so for people who don't know, it used to be that the FCC had all these rules about who could own media companies, who could own what media companies. There were restrictions about whether or not foreigners could own media companies. There were incentives for women to own. You couldn't cross own between newspaper and radio, stuff like that. And the court or the government had thrown out a lot of those rules. And then this case resulted out of people saying, well, you threw out all these rules. There's no more protection anymore. Is that a fair summary?
Yeah. No, you got it right. I'm, a cynical of forced diversity, of, discrimination to achieve diversity. And that's what these rules were about. Now, to be fair, they were not thrown out on, sort of equal protection grounds. They were thrown out as the rules being okay under the Administrative Procedures Act, which is kind of how, at least since the Trump era, that's how you challenge things. It used to be that the government got a lot of deference when it comes to the Administrative Procedures Act. But at least since Trump, courts, have scrutinized it very, very closely, and a number of important Trump initiatives were struck down on that ground. But in this case, the court said that the APA was satisfied, and so the challenge failed. But it is a victory, if only indirectly, for those of us who don't believe in reverse discrimination to achieve diversity.
Well, and I think especially in terms of the fact that the definition of media, the idea that media laws that were written even 10 years ago are applicable to our media environment now. You want them to be much more specific and much less broad in terms of the things they brought in there. So I think one of the really fascinating things about the court this term was some of the odd bedfellows that got together to make a political decision. In fact, I was talking to a friend of mine before this. He's like, the people who are really into it, you can tell them who was in the majority. And in some cases, they'll be able to tell you which case it was just based on that. So this one, Roberts, Breyer, Sotomayor, Kagan, and Kavanaugh against Thomas Alito and Gorsuch. And this is Torres versus Madrid. And it's a Fourth Amendment case, right? And the question is physically restraining somebody a Fourth Amendment issue? And do you want to tell us a little bit more about that case?
Sure. As I remember it, the main issue there was whether if you don't actually succeed in restraining the person, is it still a Fourth Amendment issue? And the court was very good, again, from a libertarian standpoint. The court was very good in criminal procedure cases. We already talked about Van Buren. Here, I thought, it was a victory for those who do not believe in unrestrained government power. There were a couple of other similar cases like that. One involving the caretaking exception to the Fourth Amendment, which is, if basically they're worried that you're dead in your house or something, can they right. break in? And another had to do with sort of live pursuit, about whether that gives them the right to go in your house, regardless of what, if they're pursuing you for a violation of the dog laws. And those all, came out in favor of defendants, really in favor of limited police power. Right. And they often have, interesting configurations, because sort of for different reasons, the liberals on the court tend to be pro-defendant, and some of the more libertarian conservatives on the court believe in limited government.
And I thought it was a fascinating thing to see that sort of the Kagan Roberts alliance on this issue that showed up in a couple other cases. Now, the president showed up in a couple cases as the litigant. There's Trump versus New York and Trump versus the Sierra Club, and and sort of looking over these things, it's sort of Donald Trump against the powers trying to resist executive authority. And did either of those cases leap out at you? Do they seem like things that are important precedences?
I'm not sure how much precedent really came out of those. They were very fact-based, and at least one of them, if I remember, was jurisdiction-based. I think the court there was sort of looking not to, frankly, thought of this as a special case and was looking not to make a lot of law, to decide it largely on the facts. And, in a sense, it turned out okay, because I don't think the court wanted to give Donald Trump protection, but they also knew that this was a fishing expedition. And in the end, the goal, which was probably to release his, leak his tax returns before the election, did not, for the most part, did not happen.
Right. And then the Sierra Club one is essentially, can the president divert military funds into paying for the wall? And, that was the sort of it's still pending. They, or at least as far as I can tell, it's still pending. So they haven't come up with a conclusion about it, but it leads to an interesting thing in terms of the idea of the court being, in many ways, with this conservative and a more libertarian bent than it ever seems to have had. I say that coming from as a libertarian, that there may be more limiting restriction on the powers of government in the upcoming terms. Having seen this session gone past, do you feel like there is more of that? We're going to limit government overall in the court?
Maybe a little bit. Certainly Gorsuch is, probably, if you're looking for a sort of conservative leaning libertarian, I think Gorsuch is best in that regard. I think, it's somewhat of a, somewhat of maybe age related, in that sort of, the older conservatives, Thomas and Alito, especially, on criminal matters, are not that concerned with government power. The younger ones, Kavanaugh, Gorsuch, I think are. Barrett, I don't have a good sense yet, but again, given her age, I think, it makes sense. The younger ones grew up in an age where government was too big.
Right. And so now the interesting thing that everybody's going to talk about is the fact that we've had two Supreme Court justices die in office, which, leads to this interesting idea that, at least now, I think, certainly Ruth Bader Ginsburg, there were people who were urging her to retire while Barack Obama was in office. I don't think anybody thought she was going to outlive her good friend, Justice Alito, but sorry, not Alito.
Do you mean Scalia?
I mean Scalia, yes, thank you. I don't think anybody thought Ginsburg was going to outlive Scalia, but seeing this now and seeing the ages of, some of the older judges, I mean, Thomas has been there for, it seems like forever ago that there was that giant fight over his nomination. Do you think that, there is a thought now of hold out to the next administration that will appoint a justice who will correct me, or the justices, once they get in, seem to think, what, I'm going to serve as long as I possibly can?
Well, I think we always look at it from the outside as a political decision. What will this do to the court? I think we forget that, for every human being, their own personal life is, probably the most important factor. And so it's a question of, does Breyer want to retire? Maybe feel some slight obligation to, retire in a way that will lead to a similarly liberal justice being appointed. But I think a bigger factor is, do I feel like retiring, or do I feel sharp and full of energy and, want to continue? I think we always sort of downplay that aspect to it. You know, again, there were a lot of groups on the left that were trying to pressure Breyer to retire. I mean, I think it's, you know, ineffectual. I mean, if you just put yourself in his situation, you know, no one, even if he was thinking about it, nobody wants to be browbeaten into it.
Well, especially I think too, the ability to write opinions and to write dissents, that's such a personal thing that you worry nobody else can say what you were going to say, even if you get somebody ideological.
Yeah, I'm sure every justice, thinks that they're replaceable in that sense, and in some extent they are. You know, they all have their individual way of looking at the law in the world.
Yeah, I remember reading Thomas's dissent in Gonzalez versus Reich. The essentially it was the government cited the
marijuana
clause. Yeah, as the Commerce Clause is the reason why they could regulate medical marijuana. And Thomas wrote in his dissent, if the Commerce Clause can be used to regulate medical marijuana, it can also be used to shut down quilting bees, which I thought was just an outstanding comment, and nobody else would have written it like that. So let me
I mean, there was an interesting one of the interesting issues there, of course, was if something's illegal, to what extent is it part of interstate commerce? But putting that aside, the Commerce Clause, as you know, I mean, I referred earlier to FDR not being happy with what the Supreme Court was doing prior to 1937, and that was mostly it was striking things down because they were not within Congress's Commerce Clause power, which originally actually was a meaningful restriction. And then basically after FDR intimidated the court and eventually got to replace the justices, there were really no teeth left in the restrictions of the Commerce Clause. And there have been a couple of cases, in my lifetime, including one that I worked on, U.S. v. Morrison, involving the Violence Against Women Act, that put some limits on it. But for the most part, Thomas is right. We're not a better nation, certainly not a freer nation, with a Commerce Clause that basically covers everything.
Yeah, it's one of those things that when I talk to people about it, and I mentioned that as, at least in my opinion, one of the worst decisions in my lifetime. Obviously, there's Kelo and Hybl and a few others, but that expansion of government power to regulate commerce is just shocking to me. Now, are there any other cases? I mentioned New Hampshire versus Massachusetts. Any other cases that the court didn't take that leap out to you as things that are going to have a larger ramification, things that they ignored or chose not to hear?
I think at least among conservatives, probably the conservatives were happy that they finally took a gun case. Since Heller and McDonald, they had pretty much done their best to, with a little help from New York, to avoid really, putting any more teeth into the protection of it as an individual right. Now they've taken the case, and we don't know what they'll do with it, but we'll see. I think the biggest disappointment was among conservatives was probably the fact that they didn't take what is it, Arlene's? I always forget Arlene's flower shop, which was one of these, religious liberty versus basically LGBT rights cases. They also dealt with that in another case this year, Fulton versus City of Philadelphia, which we can talk about if you want, because it was surprisingly I think I can't remember if it was 8-1 or unanimous. I think it was unanimous, but people were hoping that they would take Arlene's flower shop along with Masterpiece Bake Shop are the two cases I think conservatives follow most closely, and the court didn't take it again. It's just so hard to figure out why they don't take a particular case.
Right, and it's interesting because it leads to a couple of things of that. You see slightly different iterations of cases coming around all the time, and one of them is we talked about the fact that there was another Obamacare ACA case that came up, and they ruled that it's essentially made the idea that I think that's California versus Texas, and we talked about it a little bit. And one of the things that I'd heard was somebody said, this is probably the last, right? Obamacare came through now 8 years ago. Do you think that we've seen the end? Have you heard of any more Obamacare challenges that are coming up? Or is this sort of saying, look, it's clear that with this court, this ruling, there's never going to be a major reversal absent a change in the country's temperament on Obamacare?
Sure, there might be a legislative reversal at some point. Not that I'm expecting that either. But no, if you mean a challenge that goes to the heart of Obamacare, really, that would lead to the possibility of it being struck down. No, I'm sure people will continue to bring them, although they pretty much will be wasting their time, because as people pointed out, 10 years ago, once these things get, established and people depend on them, it's just politically too hard to get rid of them. And you can say, well, the Supreme Court, is not a political body. Well, look at the original Roberts vote in the 2012 Obamacare decision.
So that's certainly fascinating. We're getting towards the end of the show. What do you think? What fascinating cases are percolating up through the appellate courts right now that you think are going to make it in the next cycle?
I don't. I have not looked that closely, but I would like to see the court do more with the Administrative Procedures Act. A little. Again, I don't want to bore the audience, but a lot of the problems with the administrative state being big and unaccountable comes from there being too much deference. There's a variety of names for it, including Chevron deference, and the court has shown in the last few years, some willingness to sort of tighten up on that deference. I don't know if they're quite at the point yet of repealing it, but I think that's an area where we can actually do some good for constitutionally limited government. So I'm hoping that they'll take more of those cases. I know they're going to have to take more. I know they didn't take Arlene's Flower Shop, but they've the religious liberty versus LGBT rights cases that they've taken. They've decided quite narrowly. The Fulton case was decided narrowly. The first Masterpiece Bake Shop case was decided narrowly. This is an issue that's not going to go away. I think eventually the court is going to have to face up to it, even though it would prefer not to. And I don't know about this term, but certainly, as you know, there's a lot of antitrust suits percolating now against big tech, and I suspect some of those will be making their way to the Supreme Court, and there'll be a lot at stake there. And we've had a good version of antitrust law for the last 40 plus years, the consumer welfare standard, and unfortunately liberals are teaming up with anti-big tech conservatives to try to get rid of the consumer welfare standard, and the court's going to have to address that.
It is interesting, that alliance, because you see a lot of people who proclaim themselves to be pro-business, but saying, oh yeah, I've been restricted by tech companies, and therefore now I'm against business in this respect, which leads us to the last case that I want to talk about, which is somebody said it is without question the wealthiest combination of plaintiff and defendant in the history of the court. And I'm talking about Google versus Oracle. And do you want to tell people a little bit about that case, and then sort of where the court came down on that? Because for me as an engineer, and I know you as a former software guy as well, Google versus Oracle is a really interesting case.
Yeah, and we also submitted an amicus in that case. And the issue there was basically Oracle owned the rights to Java, which is basically the programming interface that app developers typically use. It's been very successful, very popular. So if you can code an app in Java, it's easily portable to a variety of platforms. And Google for a while negotiated for rights to it. They wanted to use it to build the Android operating system. And then at some point they just said, screw this, we're just going to do it anyway. And in a very poorly written decision, Breyer basically said that what Google did was all right. I mean, he's known to be, I guess you could say, believe in weaker copyright protection. So where he came out was not surprising, and it was hard to know where the court would come out because there's not that many of these cases. But it was just so poorly reasoned. He basically just skipped over the first step of the analysis. Was is this copyrightable? Can you this Java interface? Can you even have a valid copyright in it? And I skipped over it because I think he didn't like the answer, which is yes, and went straight to fair use issue, which is basically, well, do you have a good excuse for using something that's copyrightable? And his analysis was just very poor. And the idea that you can just skip over the copyrightable analysis. But it just shows that, when the court wants to reach a result, it will reach that result with.
Well, and I think it's fascinating because it brings us to the idea that, as we get a more modern court, or more modern technical issues and aging justices, sometimes we're going to see that conflict between, issues that are on the cutting edge of technology and justices who aren't necessarily understanding of what the issues are. And this is one of those cases. I mean, full disclosure, I was a Java software writer for 25 years. That was how I made my living. And I had come in back in the days when, much like a drug dealer, Sun and then Oracle was giving away Java for free so that you get the taste, and then wanted to charge people for it later on. Well, I want to thank you very much for being here, Curt.
They weren't even.
Go ahead.
By the way, they weren't even necessarily going to charge Google. They were basically either license it and pay or get it for free, in which case you had to make what you developed open source. Google decided to do neither. Google certainly could have afforded to pay. There was involved, but you're also right that it's probably too much to expect the judges to understand the nuances. As someone who once patented I guess what people would now say you couldn't patent because it's an algorithm. I certainly was, sympathetic to Oracle's side, but to understand the nuances of the difference between, Google tried to make this distinction between implementing code and the interface code
and the other detailed technical issues about that. Yeah, I agree with you 100%. So our guest for today has been Curt Levey. Curt is president at Committee for Justice. You can find out more about the Committee for Justice at, we put the URL down there at the bottom, committeeforjustice.org. And Curt, what should people be looking for from you guys? Sorry, that's the wrong screen. From you guys in the next coming months. Clearly, just because the court's not in session doesn't mean you get a giant vacation.
No, we don't. And in a sense, we were all praying that Breyer would not retire. There's sort of a joke amongst those of us who work on Supreme Court confirmations that, don't make any very firm summer plans, because of course that's when the confirmation battle will be, if there is one. So we're all relieved that there isn't one. And for the next few months, we'll probably focus a lot on the antitrust battle frequently. It's in the courts, but it's also in Congress. I think at some point you're going to talk to my colleague Ashley Baker more about that. But that's a very important front right now, between those who believe in a free market and those who don't. The idea that if you just hate an industry enough, like big tech, and believe me, I don't like them.
Right.
Even though, like you, I was in the tech industry, I don't like the bias against conservatives. But the idea that government regulators or plaintiffs' attorneys are going to make the situation better I just think is
Right.
belied by, by a century of experience.
Yeah.
And so right now, for better or worse, I think, if that's the most important battle going on, at least within the conservative community. And if we lose the conservative community, we lose on this issue, because liberals are only too happy to regulate and big corporations.
It's interesting because I do think that it's one of those things that, it is the core of liberty to be able to be an entrepreneur. And when government starts to impose limits on entrepreneurship with the idea that, if you become too successful, they're going to take that away and say, oh, no, the state has to be able to have control over what the market looks like and who's doing what. When in reality, I mean, one of the
we do.
I was just going to say, we do have been said, I'll go and then I'll let you go, is that there's never been a monopoly without the support of the government, right? There is no monopoly unless, Microsoft doesn't have a monopoly without IP. AT&T doesn't have a monopoly without Kingsbury Compromise, all that stuff.
People sometimes try to portray it as, well, either you have innovation.
I am going to take that as a, Curt's signal cutting out them. We're just going to follow up and say, this has been a great show. Curt, I think that's them telling us that our time is up. So committeeforjustice.org, lots of exciting stuff going on for you guys in the off season. You guys have a newsletter that people can sign up for. And I imagine there's a donate button on that page as well.
I imagine there is. So,
all right.
You could always use more support in the fight against big government. So.
That's awesome. Well, thank you so much for joining us. Thanks everybody for being here. And we are going to be back tomorrow with our On the Border special. That a lot of people are concerned about what's happening on the border. We want to take the politics out of it, and we just want to highlight people that are providing aid that are not the government. There are a lot of private organizations that are helping out right now with the border crisis, helping people, supporting border agents, supporting people seeking asylum, supporting everybody in this stressful situation. So please tune in tomorrow at 1:00. We've got a wonderful list of guests. You can find it on our Facebook page, on our YouTube page, on our web page. And I hope to see you guys all tomorrow. My name is Dan Fishman. I'm the Executive Director of People for Liberty. My guest was Curt Levey from the Committee for Justice. And I look forward to seeing you guys soon.